All right, well, thank you, Madam Chair. Our report will not be as lengthy, but I hope it's well received. It was a great job that Donna and her group did on the first report you heard. I think one of the themes you'll see and what we're recommending here is trying to be sure we maintain good communication within the agency and the communities that they represent, all the way up the line and down the line, because we're looking at the board that is established, first of all, with the county level. There's already a legislation setting up the county board, but when I read the legislation, it just says there will be a county board. It doesn't really tell you anything about the board, who makes up the board, or what their responsibilities are. And we felt there is a need to have something further explained in the law that describes the DFAC's county boards, and has some recommendations to the county commissioners that do the appointment to those boards, the type of individuals, persons from professions or responsibilities in the community that may be appropriate to be placed on the board, and really recognize that this board serves in an advisory role at the local level within the counties to have good communications from the community to the county director and their staff about how services are being delivered, or whether it may be a way to improve things through that local level. As we find out, there are boards that are quite active in the state, and other areas there are boards that are not really involved at all. So I think once we have something that better outlines the responsibility and duty they'll have, perhaps we'll see better activity at the local level with these boards and that need of communication through the community. We also have district directors, but we felt, again, from a communication standpoint, it might be a way to have, looking at those who are serving on county boards, also have a seat, perhaps the chairman of the county board, have a seat on an occasional basis at the district director's level, to again bring information from that community that may not always be brought up, and more open channels of communication from the local level to the district director, to be sure that if there's a problem there, the district director has that knowledge and information to be able to address how to find a solution. So we talk about having the directorships at the district level, to also have a board, which is an advisory board again. And we're not trying to create more bureaucracy. It's just a means of trying to find communication channels that may not exist today. We look at the director, Bobby Cagle's position, and we're very fortunate we have a great man serving as our director of DFACs. And we felt that the problems that may have been somewhat encountered in the past, there's never been really all of the governor gets the blame. He doesn't always get the credit, whoever the governor may be, when something happens in the state that becomes a public item, publicity being not always the best, as we find out for DFACs, but when you have a crisis, the governor's the one who has a responsibility, and although I'm sure he has maybe some say-so, or she does, as to who that director is, we felt that the best approach would be to have the governor given the right to have the appointment of a director as well as the removal of the director. The director, all at the current time, is all under the commissioners of the Board of Human Services and that board. We're not looking to do away with the relationship between so much with DHS and the DFACs, but to have DFACs put in a more autonomous position for the ability to recognize the importance of this agency to the state and to the children and families of the state. So the purpose of this is to say the directorship will have a direct line of communication from DFACs to the governor's office, and yet their budget will still be an item carried through the DHS process of appropriations. And your board of the commissioners board will still have the final oversight, especially as to rules and regulations that are to be adopted. And I'll explain one of the reasons we left that as a matter within the commissioner's office itself as far as the board and DHS. So this is a way we felt to make a stronger relationship of the director to the governor, and also be sure that it does not become a political appointee as such. We want to have in the law outlined what are the qualifications of the person who would serve as director. For instance, a master's degree in social work would be possible one, or a bachelor's degree in social work, but also have the experience working in that area as a part of the background and the administration of the work itself. So we expect the law, if it's to be changed, to have defined terms and requirements for an individual to be named as director. The other thing we have is a DFACS State Advisory Board. This is again part of the communication channel that we see being set up. So you would have individuals who come from each of the districts. You have 15 districts in the state, so to be sure that geographically everybody is having an opportunity to be represented at the state level, you would have one person from each of the districts serving on this board. There would be other individuals that we would suggest be also recognized to be serving on the board, as we define in here, people who are the areas of public health, mental health, developmental disabilities, juvenile justice, and others involved in communities. Now, those people could also be the ones coming from the districts, but if they're not appropriately represented, then there will be a slot there for the governor to consider using a group of about 20 people. We see a group in here today that consists of around 20 plus people, so I think this advisory board at the state level for DFACS should be appropriate in that same sized range as a way of, again, fulfilling the communication between local boards all the way up to state level. Another area we've had lacking of ability is to get information between the agencies, and we've adopted a provision here. I'll read it. Encourage the legislature to review and find permissive limits to address this issue, ensuring that consideration is given to immunity between agencies that share data.
So would that include like the DOE, hospitals?
Absolutely.
That falls under that.
And we were saying to the extent permitted by law, because there are limitations, for instance, in the health field as to what you can and cannot share of that type data. But where we are able to do so, and if it's a concern about, well, if I give this information, do I become liable to a third party or to that family or that child, we want to be able to establish to the extent that we can provide immunity for that reason. We've done this past year when we did the adult abuse legislation. One of the things we encouraged in there was, of course, part of the reporting. We told financial institutions, if you report the information, you see someone who's coming in drawing down, say, $10,000 on an account, and the person only has, that or a few dollars more, and you wonder why they're doing that. Let there be some immunity established in the law to really encourage a person to report this to appropriate law enforcement officials, for instance. And I think the same thing might be a step that we can consider here if it's necessary in order to encourage the sharing of that type of information. Custodial records, review and extent to which statutes and rules, regulations allow sharing of mental health, physical health, and conduct records. This comes on the part of the same thing of the sharing from DFACS to care providers when such information is beneficial to the provider in caring for the children in their custody. This is especially true with those who have foster home care of children. There needs to be the ability from DFACS, when they have this information, to be sure that those who have custody of these children are aware of the health issues that are facing that child, so they can better be prepared to deal with it as issues arise. So we think there needs to be some perhaps legislation to address that issue. The last thing we have as a bullet point is the Child Abuse Registry. As we discussed in this commission, there is a case came out of the Supreme Court a number of years ago that state Supreme Court that prohibits a registry. The prohibition was really because it did not provide for the right of due process, their name being entered on that registry. That's the Roberts case, and we think this can again be reviewed and addressed by the legislature to be sure that if the law is passed, that we recognize the standards of due process before someone's name is put on that list. That covers the items of our report, Madam Chair, and I'll be glad to try to help. I want to answer also the people who served on our committee, Judge Steve Teskey and Ashley Wilcott, Tyra Walker, Dwayne Hathaway, and Senator Burt Jones, and myself. So we've had a good group of people looking at these various issues, and all of them provided great support to it.
Are there questions about these specific recommendations?
I'm not sure I understand the defects in DHS structure, because when you say the word oversight, one of the problems we run into in the last 3 administrations is the defects would come up with a budget and a proposal, and the DHS commissioner would say, we're not going and asking for that. So I'm real concerned about that piece of it, and having that ability to filter what comes to the budget request.
That's a good point, Judge. And what we were looking at there as a mechanism of recognizing from time to time during the fiscal year there may be a need to obtain additional funds. The Department of Human Services has perhaps a better pocketbook out of which that adjustments could be made because of the defects funds being pretty well committed to the dollar all the way through.
That pocketbook does not open readily.
No, it doesn't. It doesn't. And we're open to ideas here, believe me. This is something the governor's office hopes to be helpful too.
And Bobby, I don't know if you have something to say. I mean, I can speak to this just from what it's been like, having seen it on both sides.
And the defect director directly reporting to the governor is just a game changer in the way that operation works. So, I mean, right now, I see Bobby a lot. We meet every Monday morning with our senior team and Bobby and Katie Jo. So, you know, I think those lines of communication are really strong. It's just like when we increased the funding for caseworkers, you know, that didn't go through DHS. That was because of direct communication with Bobby. And so, I hear your point. I think it's a really good point. I think the defect director reporting directly to the governor takes care of that issue. But Rick, I don't know if there's anything you
I agree
want.
wholeheartedly. I mean, I think with that reporting arrangement, if there's something defects needs, it can be brought up.
And Rick, of course, is in those meetings as well from a budgetary standpoint, and so, you know, we're all in very close communication and work really closely together.
I think it's important to know, though, as a part of the recommendation, that structure, if that's what, you know, was agreed upon, is contingent upon the defects director reporting to the governor. I think we need to make that very clear.
Very true.
How we put forth that recommendation.
I might also add one thing further, Judge Walker, that is that the advisory board, one of the reasons we left it as advisory board at the state level is to recognize we have on here the potential appointment of legislators who could serve on that board if it remains as an advisory capacity as opposed to a rulemaking and regulatory body. Legislators could not serve. And I think it's important that we have with this state level defects board a means of good communication between the board, the department, and the legislature as a way of being sure needs are being addressed and hopefully provided for.